Toronto appellate lawyer Cynthia Kuehl is here with us today with Lerners Appellate Group's top 5 appeals for summer 2012. Well, Cynthia, let's start at the top. What's number 1?
The first case has to be Taylor in Canada. It's a 5-member panel of the Court of Appeal on a special case brought pursuant to Rule 22 in the context of a motion to decertify a class proceeding on the basis that the pleadings don't give rise to a reasonable cause of action. And in particular in this case, the issue that the court has to address is whether or not it is plain and obvious that there is no private law duty of care owed by Health Canada, a regulator, to the individuals in the class. And Justice Dougherty looks at the factual circumstances of this case and says, here it can be made out, not that it is made out, but it could be made out, that Health Canada is in a different relationship to the users of these implants than it is to the public at large or to consumers of medical devices. Therefore, the test for a possible private law duty of claim has been met, and at least at this juncture, it's not plain and obvious that the case cannot succeed.
I understand the second one deals with the Deemed Undertaking Rule.
It is one of our sexy rules of civil procedure, the Deemed Undertaking Rule. This is Mamo and Sobeski. Mamo is a family law lawyer who represented Ms. Sobeski in matrimonial proceedings and as a result received documents from his own client. He then is sued by Mr. Sobeski for defamation and wants to rely on the documents he got from Mrs. Sobeski. So the issue is, does the Deemed Undertaking Rule apply or can he not rely on those documents? The Court of Appeal overturns the motions judged below, finds that the Deemed Undertaking Rule does not apply because the documents were not obtained pursuant to Rule 30.1.01 sub A of the Rules of Civil Procedure.
The third one handled contractual interpretation, isn't that right?
It does. In that case, Downey brought an action against Ecore International in Ontario arising from the termination of a consulting and confidentiality agreement he had with Ecore. And in particular in that case, Ecore then moved to stay that action on the basis of a forum selection clause in the confidentiality agreement. Downey's company had executed a consulting agreement. Downey had personally executed the confidentiality agreement. He says the forum selection clause, and particularly the confidentiality agreement, had no consideration. The motion judge agreed. The Court of Appeal and Justice Counsel, writing for that court, set that aside, saying it resulted in a commercially absurd result, or words to that effect, and didn't give fair regard to the factual matrix. You had to look at both of these agreements together. Downey got the benefit of the consulting agreement. As a result, Downey's got to bring his action in Pennsylvania.
And the fourth one?
Indcondo and Sloan. In that case, Court of Appeal deals with two really divergent issues. The merits of that case really deal with the fact that the appellant had received a Section 38(1) order which allowed it to pursue a fraudulent conveyance claim against Sloan and others. And Sloan sought successfully below to have that action dismissed on the basis that it was abuse of process because the appellant had brought its own action in its own personal capacity that had been dismissed and because Sloan had been discharged from bankruptcy. The Court of Appeal disagreed, saying that really the appellant was stepping into the shoes of a trustee, of the trustee in that case, so it was distinct from the action it brought in its personal capacity, and further that the trustee was really not interested in the discharge and therefore, not interested, but didn't have a position in the discharge and therefore the action could proceed. The other interesting issue in that case is that the respondent had tried to get security for costs against the appellant's lawyer because of a contingency fee agreement. The Court of Appeal says you can't do that. It would chill access to justice.
And finally,
the Association of Justice Counsel and Canada, really interesting case dealing with a constitutional challenge brought pursuant to Section 2D of the Charter. The association represents and is the certified collective bargaining agent for almost 3,000 federal government lawyers. It says that the Expenditures Restraint Act offends or violates Section 2D rights because it impacted upon collective bargaining. The Court of Appeal says and cites a recent case by the Supreme Court of Canada called Ontario and Fraser for the fact that Section 2D only ensures that you have a meaningful process in terms of collective bargaining. It doesn't guarantee an outcome. It doesn't guarantee that if you can't reach an agreement that there's going to be a particular way to bridge the impasse. And in this case, based on the facts, there had been a meaningful process prior to the Expenditure Restraints Act being passed, and as a result, there was no violation of Section 2D.